Today we'll talk about the case against judicial activism.
But really the question that I want to ask, which I think is the key part of our conversation, is what are the harms of judicial activism? And I think this is not an intuitive question, or at least not an obvious question when talking about this issue, and it's very rarely asked that way. And in a moment, we'll jump into exactly what that means, why we're asking about the harms of judicial activism, how that ties in to the broader objections against judicial activism. But beforehand, I think it's worth making a few quick preliminary remarks and observations. First of all, I think we don't need to remind anyone in this room that we're living in turbulent times of great geopolitical upheaval, times in which the future of the existing world order may hang in the balance. And one might justifiably ask, is this really the most important topic of the day? Questions of judicial power and its use and abuse. And to this I will answer very shortly and simply that, as I explain in the book in the Israeli context, the fundamental must cede to the existential. And this is something that happens all over the world. Nonetheless, issues of this kind, issues of great importance and great gravity, even though they're non-existential issues, so to speak, they continue to press upon us, and they become no less significant even in times while we are waging war. Before we consider judicial activism itself, I want to acknowledge, or to sort of raise as a background for this issue, a broader phenomenon. And that is the radical expansion of judicial power in the West over the past 40, 50, 60 years. The second half of this 20th century, and especially the past 40 years, have seen the unprecedented growth of judicial power in all its forms. And this is relatively undisputed. And I'll give us a few examples of this. I think this isn't something that just really needs too much explanation, but this is a phenomenon that's happened all throughout the West since really the post-World War II order that we've seen all over the place. I'll give one quote from Professor Martin Laughlin from Oxford University and London School of Economics. And he explains how in both, and this is a quote, in both new and well-established constitutional regimes, the range of constitutional judicial review has extended dramatically and strengthened in intensity. Across the world, judges are now reviewing contentious public policy questions that a generation ago were assumed to be beyond their competence. And he talks about how this has played out. He continues, the judiciary is now bidden to adjudicate a broad range of disputes touching on fundamental aspects of collective identity and national character, et cetera, et cetera. And this is just one example. This is from Professor Laughlin's book, Against Constitutionalism. But this is something which has been tracked and has been discussed by scholars for the past few decades. One more example is Professor Ron Herschel in his book, Towards Juristocracy. Constitutional reforms, he discusses constitutional reforms that have transferred an unprecedented amount of power from representative institutions to judiciaries. And just to list a few books that have discussed this issue, you have in the 90s, you had a book called The Global Expansion of Judicial Power by Tate and Valander. You had a famous book by Judge Robert Bork, the American federal judge, who wrote his book in 2003, Coercing Virtue, The Worldwide Rule of Judges. And I mentioned Ron Herschel's book in 2007, Towards Juristocracy. This is just a sort of demonstration of a few of the examples of the scholarly work on this issue. Now, what's important to know when we're talking about this expansion of judicial power in the West is that some of it came about as a result of deliberate democratic decision-making, right? Constitutional reforms and different kinds of legislative reforms in different countries. However, a great deal of it, of this newly acquired judicial power, was not granted or conferred, but was rather seized. That is, a staple of this process that we've witnessed over the past generation is that judges and courts have been the primary engine driving the expansion of their own power. They did this unilaterally, they did this proactively, and this is again a staple of the phenomenon that we've seen all throughout the West. This brings us to judicial activism. I should say I write in the book that sort of the end point of this, or the point that we are today, is that the judicial pen is in many ways mightier than both the purse and the sword. But this brings us to judicial activism. And of course, I think what most of the people here in the room know is that judicial activism is an elusive term. And despite its, I suppose, its prevalence or its prominence in debate and discourse around judges and judicial decision-making, there are actually very few analytical frameworks. There have been very few efforts to define and to fully examine the definition of judicial activism in a disciplined, systematic, and analytical way. So I will sidestep this thorny issue for the moment, and we will not try and offer a robust and comprehensive idea of what judicial activism is. But what I will say for present purposes is something along these lines. Judicial activism, for our purposes right now, is a form of lawlessness. It is the decision by the court to base decisions, judicial decisions, on anything outside traditional notions of the law, whether it's ignoring the law as we know it, whether it's distorting the meaning of the law, again, as we might be familiar with, or of course, if it's sort of inventing the law or really relying on ex-legal materials and sources in order to reach its conclusions. Now, it's worth saying, first of all, that's not necessarily a negative or a pejorative description. Many would argue that there are strong justifications for judges and courts to rely on ex-legal, right, on extra-legal, I should say, materials, which are not, don't conform to the traditional notion of what we call law. Another sort of interesting side of this, and then with this we won't go too much further into the idea of judicial activism. Another interesting side of this is the very terminology that we use for the idea of judicial activism. It's interesting, if a police officer were to invent a crime that doesn't appear anywhere in statutory law and then arrest one of you for that invented crime, we don't call it police activism, right? We just call it doing something illegal, and they might go to prison for it. And of course, there are many, the same is true if an official of the IRS decides to simply ignore some provision of statutory law and simply will announce that they refuse to apply that provision because it does not conform with their own subjective notion of, great values of justice and morality and human rights, etc. We don't call that tax activism or IRS activism or official or clerk activism. Nonetheless, when judges do things which are quite similar or sometimes even identical, we call it judicial activism for some reason. So that's something to think about. But for now, we will skip onwards from our idea of from our definition of judicial activism, and we will simply concede that this idea exists. Of course, the mirror image of judicial activism is in many senses, or most people regard that mirror image as judicial restraint, or as Professor Randy Barnett likes to call it, judicial constraint. Now, this isn't restraint in the notion of courts shying away from doing their duty, or from not being willing to rule on issues, or from not even intervening in government action. This is judicial restraint or constraint in the sense of being constrained by the law in the traditional sense. So the idea that judges and courts have to apply the law as it is, not to ignore provisions, not to rely on extra legal sources, not to distort the meaning of the law, etc. I've always found that one of the most interesting descriptions of the tension here, of the two different sides of this, comes from Justice Cardozo, who wrote in his book on the nature of the legal process. I think I'm misquoting it, but that's a paraphrase. But I've always liked this passage. I'll say, and I should, full disclosure, Justice Cardozo is a distant relative of mine a few generations back. He has this wonderful passage where he says, "The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant," I love that, a knight errant, "roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw his inspiration from consecrated principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence, et cetera, et cetera. And he goes on a bit about this. I always found this to be very interesting, sort of this, description of the knight errant, right? You have the judge who wants ultimately to achieve an outcome of justice, who wants to do right, and yet you have this idea of being subject to a discipline, of ultimately having to limit your decisions and your decision-making process to the conventional ideas of the law. Coming in a moment to the core of our discussion, to the case against judicial activism, what we've seen over the past years, of course, you've had this raging debate, right, between judicial activism and judicial restraint in many different forms, in many different ways. And what we've seen is that the justifications for each of these in this debate differ in a very, very important way. And I think in a way that has always given judicial activism something of the upper hand. Judicial restraint has always been defended or supported or argued for in terms of principle, in terms of process-related arguments. And what I mean by that is people will argue in favor of judicial restraint in the name of separation of powers or democratic authority or other similar, we can call them almost deontological, but even if not so, at least not consequentialist arguments. These are arguments about the principled importance of doing things a certain way. On the other hand, at the same time, judicial activism is very rarely defended on grounds of principle. Rather, judicial activism has always traditionally been defended and supported on the idea of the outcome being desirable. And this has always been an outcome-related consequentialist argument in favor of judicial argument, and you can in favor of judicial activism. And you can understand why this is such a compelling and attractive idea. What the central premise of judicial activism has almost always been, look, we understand these principles of democratic authority, of statutory fidelity, of separation of powers, but here is a distinct injustice. Here is something that we can clearly see is wrong. Here is something that we can clearly object to. And here we have the opportunity of a judge by an official order, a judge by judicial decree, to alleviate that harm, to mitigate this injustice. So you can always see the great temptation of judicial activism and why it's so compelling, because I think, generally speaking, outcome-related arguments tend to be more compelling and more attractive to us human beings, especially if we have a developed sense of justice and morality and fairness, etc. And here we come, I think, to the crux of the issue and to the argument I'd like to make today.
Right.
And this will, of course, in a moment relate to my book and to the Israeli legal system. The argument that I will make is in the past, the experience of the past 30 or 40 years, and especially probably the past few decades, we can now see quite convincingly, and we can say with much confidence, that there is a very strong consequentialist argument against judicial activism, in the sense that today we have an outcome-based case against judicial activism, because we have seen over the past 20, 30, and more years how judicial activism across the West has generated significant, direct, tangible harms. It has yielded catastrophic results throughout different societies in the West. And what I mean by that, I guess why this is important, is that the objections to judicial activism no longer need be based solely on issues of principle of such as separation of powers and democratic authority and et cetera, and the rule of law, et cetera. But rather, we can now, I think, we have sufficient experience to say with confidence that judicial activism creates very, very, very bad results. And the key way that I'd like to demonstrate this point, and one of the key examples for this, is indeed the Israeli legal system, which I will describe very briefly in a moment. But I think the Israeli legal system provides a microcosm or an example of what happens when you have a court that goes completely off the rails, when you have the most radical, rampant form of judicial activism imaginable, and it certainly is one of the worst transgressors in the West on this issue, and serves in many ways not only as a cautionary tale, but also as an example supporting that argument of the severe consequences of judicial activism. So a few words very briefly about the Israeli legal system. I won't go into too much detail on this issue because I wrote a whole book on it called Rogue Justice, The Rise of Judicial Supremacy in Israel. And if you'd like to know more about that, you can read it. But I will say a few very quick words. The Israeli Supreme Court is considered among the most activist in the world. This is almost undisputed amongst scholars of constitutional law. One scholar in 1995, Martin Edelman, wrote that judicial activism, or as he described it, the judicialization of politics, he said, had proceeded further in Israel than in any other democratic country. Other scholars who write these kind of comparative studies, like Robert Bork, who I mentioned, like Ron Herschel, Israel is a staple example in comparative jurisprudence when discussing the issue of judicial activism. Perhaps especially instructive is that in 1995, two constitutional law professors from UC Berkeley, not too far from here, conducted a survey, a poll of different comparative and constitutional law professors. And that poll was to see which Supreme Court, which jurisdiction had the most activist court. And of course, amongst all these different constitutional scholars, Israel took first place as the world with the most activist court. I should say that the United States was second. What makes all this interesting, both in this study at UC Berkeley, but also with Martin Edelman's remarks and others, was that this was in 1995 before the Israeli Supreme Court did what is considered its most egregious and most radical act of judicial activism, which I will proceed to explain in a moment. So this is worth considering and dwelling upon just for a moment. This is just to justify for you why I think Israel is a natural example to discuss this issue. So very briefly, in a moment, we'll dive into my litany of harms, which I think one can argue were caused by judicial activism. But I'll say very briefly what happened in 1995, and especially in the context of constitutional law, which I think is especially obviously interesting to an American audience. Israel was founded without a constitution. And for the entirety of its existence, to this day, it has no constitution and never had anything remotely approaching a constitution or anything remotely like it. Nonetheless, in 1995, the Israeli Supreme Court issued a ruling called the Bank HaMizrahi ruling, and it looked at two laws that were enacted in 1992, a few years earlier. And it looked at those laws, and it said if it walks like a duck, quacks like a duck, and looks like a duck, it must be a Tyrannosaurus Rex.
Yeah.
And these two laws, which did not remotely resemble a constitution, which nobody considered a constitution, which nobody had imagined or conceived of as a constitution, the sponsors of these bills, of these laws, explicitly said in the Israeli legislature that this is not a constitution and that it is not empowering the court, not granting the court the power of judicial review, et cetera, et cetera. And I go into great detail about this on the book. The court took these two laws and said, congratulations, Israel, you now have a constitution. And not just any constitution, you have a constitution that empowers the court to conduct judicial review and to strike down primary legislation. And this in itself is fairly remarkable. I think even from a comparative perspective, I like to say that there are three clubs in the world when it comes to judicial review and the power to strike down legislation. You have countries with no judicial review, where courts can't strike down legislation. To Americans, this might sound very foreign, but you have countries like the United Kingdom and New Zealand, right? These backwater dictatorships, authoritarian, totalitarian dictatorships, or who don't have any written constitution and don't have judicial review of legislation. But you also have countries like the Netherlands or Switzerland, other totalitarian dictatorships, where they have a constitution and yet they have no judicial review of legislation. It's explicitly stipulated in the constitution that parliament acts are final and cannot be struck down. Your second club is countries where courts do strike down legislation based on a conventional written constitution, the kind of constitution that we're all familiar with, right? It's that thing that we refer to when we use the word constitution, right? A document with a beginning and an end, enacted in a constitutional convention, et cetera, et cetera. We're familiar with this idea. And that is the second club, countries with strike down laws based on a constitution. The third club is like Sgt. Pepper's Lonely Hearts Band, Sgt. Pepper's Lonely Hearts Club, because it's very lonely because it only has one member, and that's Israel. Because the third club is the club in which, with only one country, a court can strike down legislation without the benefit of a written constitution. And Israel is the only country in the world, I should say in the Western world, but really in the entire world, the courts can strike down primary legislation, parliament's laws, without the benefit of a established conventional written constitution. And it is this, so in many senses, and I'm giving, this is really all in a nutshell, and I spend a great many pages on this issue in the book. But this is just to give you a taste of what might be the ultimate move of judicial activism, right? One could hardly envision an act of judicial activism or a decision of judicial activism more daring, or perhaps more chutzpahdik, we say in Hebrew, more objectionable than a court inventing a constitution and informing the public, unbeknownst to the electorate, that it had now received a constitution. So now I'd like to discuss, or to offer for your consideration, some of the harms that I think have been very clearly demonstrated in Israel, and which likely, I think, provide for us an example of how radical judicial activism, or judicial activism more generally, yields some truly catastrophic results. One is the easy one, which I won't go into too much, is just bad policy decisions. And this is not so surprising, right? Judges tend to be very good lawyers, but very poor economists, very poor accountants, poor scientists or biologists. They tend to be poor engineers. They tend to be poor military strategists, et cetera. They tend to be poor at everything except for being judges, except for a very small group of them. And it can hardly be surprising that when judges are making de facto policy decisions, these policies sometimes don't work out very well. Sometimes they have terrible results. Now, of course, I won't go into that too much because, of course, what constitutes a bad policy result is precisely the thing that we all argue about and disagree upon all the time. So that might not be sufficiently helpful. But I'll give one example in Israel. I suppose a few quick examples, which we can't go into too much, is in the field of immigration. And this is especially, I think, prevalent both in Israel, but also, for example, in European countries, where the issue of immigration has been heavily litigated, heavily influenced by judicial decision-making, much of it considered activist, setting up immigration policies which today many in Europe consider to have been detrimental, to have been deeply problematic, objectionable, and harmful to European society. Another is, of course, military strategy and national security and defense issues. And Israel is a prime example of this, where the Supreme Court intervenes in military and defense issues on a regular basis in a way which is unparalleled compared to other countries in the world. And I won't go into this, but there are clear examples in which military policies which have been affected by the court have led to very, very poor results. And many argue in Israel that some of the catastrophic failures on October 7th in Israel were partially the result of judicial intervention and military policies which were born of judicial intervention. But one last quick example that I'll give very briefly is that the Israeli Supreme Court, and here's one example, struck down a piece of legislation which established private prisons, privately administered prisons, something that I think Americans are familiar with. You have private prisons in, I think, numerous states in the United States, and this is something which is not uncommon in the democratic world. You have in the United Kingdom, Australia, I think maybe Canada, I'm not sure. The court struck down this law as an impermissible violation of the dignity of inmates, of prison inmates. This is a wonderful example of the way the court can take a term like dignity, which is a sort of vague, amorphous constitutional idea or some notion of a human right, and implement it in a way to forbid or to limit the ability of the electorate and its representatives to pass this kind of basic policy. One of the results of this, the inability of the Israeli government to administer private prisons, is that Israel today is facing a massive prison overcrowding issue. And this is what this piece of legislation was meant to deal with in the first place. And 20 years on, Israel still hasn't figured out how to address this significant issue with prison overcrowding, because one of the key alternatives open to it were taken away by the court. So that is just one example, probably the easiest one. And I hope you'll forgive me because this review will now be relatively cursory because we won't have to go down, but really each of these can be an entire conversation in and of itself. But let's jump ahead for a moment. One key area is that of public discourse and the way the public conducts its conversation about disputed issues. And in in a world of judicial activism, right, in a jurisdiction of rampant judicial activism, what happens is that the very essence of public disagreement deteriorates from disagreements of principle, from substantive disagreement on the merits, to sort of petty legal trivialities. Because everybody's arguing about, does this or does this not pass strict scrutiny? Does this or does this not fall under substantive due process, et cetera, instead of simply asking, is this a good or a bad policy? Is this desirable or undesirable? Professor Jeremy Waldron, who I think is at Columbia, has aptly noted, I think, impotent debating about what a few black-robed celebrities might decide in the future is hardly the essence of democratic citizenship. And I think he makes a good point about the effect that judicial activism has on the public debate and public discourse you have in that sense. Another key area is the exacerbation, and of course this is related to the public discourse issue, the exacerbation of societal tensions and major public disputes. So when the court, or when an activist court, intervenes in society's most contentiously debated, right, most hotly debated, most hotly disputed societal issues, these issues are not resolved. What happens is that they simply either simmer beneath the surface or they become even more acutely disagreed. They become even more acutely contested. And here I want to bring you a quote from Justice Lord Jonathan Sumption. And I don't know if you've heard that name before. Justice Sumption was a British Supreme Court justice who recently retired in 2019, and he gave a wonderful series of lectures and wrote a book on the issue of the expansion of law in the democratic world. And he writes in this context, law is rational, law is coherent, law is analytically consistent and rigorous. But in public affairs, these are not always virtues. Opacity, inconsistency, and fudge, this is his word, fudge, may be intellectually impure, which is why lawyers don't like them, but they are often inseparable from the kind of compromises that we have to make as a society if we are going to live together in peace. And what I think what's important to understand here is that many societies, including Israel, perhaps most especially Israel, but other societies as well, need a measure of flexibility. They need the ability to negotiate, to compromise, to discuss. What judicial decision-making often does, and especially in the context of judicial activism without sufficient legal basis, is it simply draws a line in the sand, creates clear winners and losers, and that's that. And instead of society having the ability to negotiate and compromise, you reach a point where simply these rules or these policies are foisted on society and the decision is made for them. As I think Martin Laughlin, who I mentioned a little bit earlier today, said in his book, the main purpose of a constitution is to establish the authority of the system of government, requiring that it maintains social peace among people with different visions of the good society. So social peace among people with different visions of the good society means that you have to be able to compromise. You have to be able to constantly also shift the content of that compromise, which is something, again, that judicial activism precludes or makes extremely difficult. Skipping ahead a little bit, I'll mention, of course, and this it's worth, I guess, mentioning in this context, another key area in which, or another key harm that we see from judicial activism is, I should call it, the superficial resolving of issues, right? The idea that a hotly contested societal disagreement can even be resolved by judicial decision-making, by judges simply saying, oh, this is a right, or this is some issue, this doesn't stand some judicial test, and from now on, this issue is resolved. And of course, one of the things that comes to mind is Roe versus Wade and the issue of abortion in the United States. And of course, we have the famous statement from the Supreme Court in Planned Parenthood versus Casey, where the court says, this issue is settled now, I think is the exact quote, right? The court says, that's it, we've taken care of this. We've now ruled on the matter and there's nothing more to argue about. And Justice Scalia in Planned Parenthood, memorably said, not only did the court's ruling not resolve the deeply divisive issue, it rather, and this is a quote, did more than anything else to nourish it. Scalia explained how the court's decisions fanned into life an issue that has inflamed our national politics, destroyed the compromises of the past, and rendered compromise impossible for the future. And Justice Scalia was onto something, because you have this problem where judicial decision-making precludes compromises, but not only that, it leaves problems simmering under the surface with this illusion as though they have been resolved. Another major problem, which I'll mention very briefly, is a total collapse of faith in the judiciary itself. And this is catastrophic for democratic countries. This is catastrophic because faith in the judiciary, and what I mean by that is faith that the judiciary is implementing the law, nothing more, nothing less. Faith in the judiciary is all the judiciary has. Other elected institutions have other sources of legitimacy, other reasons to listen to them. But the only reason any citizen has to adhere to judicial decisions and to respect the court's rulings is because of the belief that they are simply implementing the law. And the moment you cease to have that belief, you lose the very basis for all judicial compliance. And what's happened in Israel in this sense is really interesting. For a major study just came out by two professors from the Hebrew University of Jerusalem, where they showed that since 1995, the year of the invented constitution in Israel, public faith in the judiciary has collapsed. It went off a cliff. And this could hardly be surprising. In fact, this was warned by many eminent scholars and Israeli jurists since the early 1980s and onwards, when this started happening in the Israeli court, that this is exactly what would happen if the court continued down its activist path. And I'll give you just one example. Is Chief Justice Moshe Landau, who was one of Israel's greatest jurists, said already in 1979, the courts are not capable of inventing a miracle cure for the state's severe societal and economic problems. On the contrary, if the courts attempt to do so beyond what the existing law permits and mandates, they will lose the public trust that is essential to their functioning. And this is just one example of many. So already in the 80s and 90s, you had these leading legal scholars warning that the inevitable result of rampant judicial activism would be the utter loss of faith or confidence in the judiciary. There's so much more to say about this. I want to leave us more time for our Q&A. I'll list just some of the last sort of examples that we see, and this is not comprehensive. One is, of course, we see exacerbating tensions between the elected branches of government and the judiciary, and it's something that we're seeing across the West. We're seeing parliaments who are legislating more laws to curb judicial power. This is what we saw in Israel in 2022 and 2023, but in fact, this is something we're seeing again all across the West. We're seeing a pushback from the electorate and its representatives to try and limit and curb judicial power. So even if you are a judicial supremacist, even if you'd like to see more judicial activism, this is a sense in which this backfires against you. This is something which you're trying to avoid. You don't want the electorate and its representatives trying to limit your judicial power. Another important sense, which I'll mention from Martin Laughlin, who talks about this, he talks about how judicial supremacy absolves the political branches from having to face up to intractable political questions. And it offers incentives to democratic representatives to evade their most basic civic responsibilities by pushing ever more political issues into an institution that is insulated from the cut and thrust of ordinary life. So this has to do with political culture and what we expect from our politicians. And if we've noticed throughout the West a decline in the quality of our legislators and the quality of their actions, the quality of their characters, part of that is related to this incentivization of politicians to simply kick the can down the road and to pass along controversial issues for judicial resolution. Again, there's so much more to say. I'll say one last thing, which I think is perhaps the key issue, which is the way that judicial activism undermines democracy. Not in the abstract sense that it is inconsistent with democratic principles, but rather that it eats away and erodes at the very democratic spirit, at the democratic psyche of a people, of an electorate in a democratic country. And there are so many senses in which this happens. One is simply people losing faith in the very idea of democracy itself. part of this has to do with the infantilization and enfeeblement of the democratic representatives, right? If you have a court which is constantly cutting down what your elected representatives are doing, constantly telling them that they're making laws which are immoral or terrible or unjustifiable, this causes a lack of faith in your political classes and in your own ability. Well, if your politicians are so terrible, you must be so terrible for voting them in. So you have this fundamental erosion of what politicians are capable of and can do. But more importantly, you have an effect of polarization of all of society as they lose the ability not just to talk to each other, but also to compromise and to reach key agreements on key issues. Because what judicial activism does in this sense, inevitably, is that it creates winners and losers. It creates beneficiaries. And once you have a beneficiary of a certain type of judicial activism, of a certain type of judicial decision-making, those beneficiaries have no particular reason to win elections, to build political coalitions, to negotiate and compromise with their political adversaries, with people on the other side of the partisan divide. And so you have different political or partisan camps becoming more and more entrenched, more and more polarized as a direct result of judicial activism. I think we're out of time, so I think I'll stop here. There really is so much more to say. The last sort of thought I'll leave you with this idea of the consequences and the harms of judicial activism is this. I think we've seen this in the United States, we've seen this in other countries as well, we've certainly seen this in Israel, is this illusion that you can get away with the judicial activism and you can inject its policies and decisions into society and sort of get away with it. And things will blow over. You know, maybe there'll be some controversy and maybe people will be displeased, et cetera. But people will get used to the idea or certain policies will remain in place, et cetera. And what we've seen throughout the West is the exact opposite has happened and is happening. And I want to leave you with a thought that in many cases, I think this resembles an untended, festering wound at the heart of any country's national existence when you have above a certain threshold of judicial activism. As time passes, this legal infection spreads, the polity's condition worsens, the rot begins to compromise critical systems, and you have ever deteriorating cycles of convulsion and resuscitation. We see this in countries in which you have very, very strong instances of judicial activism which are not addressed, and under this illusion that we've now fixed things. And this notion that any such ailment can heal with time is a dangerous delusion. Either the contagion is properly diagnosed and urgently treated with the utmost vigor and resolve, or our patient, which is our democratic order, will ultimately succumb to the strain of judicial activism and judicial supremacy. So those are the thoughts that I want to leave with you today. I'm sorry it's a little bit sort of short and condensed, but thank you very much.
Well, you and I have spent quite a while talking about a lot of this stuff. In fact, I think we initially bonded in 2023 over our, disgust? Is that too strong a word for judicial supremacy and activism? And so we were immediately... Objections. That's much, much better, yeah. So we spent a lot of time talking about that. But I want to go back to something that you were saying toward the end of your talk. You I think, nicely defined and distinguished, I think, activism and supremacy. And, you know, I should apologize because his book is about judicial supremacy, and I intentionally derailed him to talk about activism. But I think that there's a nice distinction that you gave us there. We were talking earlier about an example that you gave just a few moments ago, Roe v. Wade and Casey. And you said to me, Dobbs, the decision from just a couple summers ago overruling Roe and Casey, was really the ultimate anti-activism case. And I wonder if you could explain for us what you mean by that, and what is an let's say an unactivist court look like?
Sure, absolutely. Well, first of all, it's worth saying, and I think I didn't really do this in our talk too much, and if you'll forgive me, I'll answer our audience and not
fine.
turn to you too much
Yeah.
so they can hear me as well.
Please.
First of all, I should say that it's true that judicial activism and judicial supremacy are not quite the same thing, even though they're often conflated. And judicial supremacy is more about judges having the last word and essentially being the final arbiters of societal disputes, whereas judicial activism is more about the sources, right, on which judges rely to make their decisions, et cetera. And I guess part of the overlap, and this is also relevant for your question, but part of the overlap is that in the last generation, what we've seen is a great deal of judicial supremacy, and especially in Israel, which has been brought about by judicial activism, which is essentially the ultimate sin, the ultimate judicial jurisprudential sin. It is judges having the final say by the power of their own decree, by granting themselves their own authority of final say. In many senses, Roe v. Wade was an instance like that, completely unrelated to the substantive disagreements or arguments about abortion and pro-life and pro-choice in this entire debate. You had a court which was making a decision which was manifestly activist in the sense that everybody knew that there was no basis in the Constitution for this decision. And I think one of the best examples of this was by John Hart Ely, who wrote this wonderful paper right after Roe v. Wade, explaining that, and this was a progressive, left-wing, really activist, pro-choice legal scholar, one of the most eminent legal scholars of the generation, saying, guys, I don't know what this is, but this isn't constitutional law. This is pretty much almost the words he used. What's that?
States' right.
Exactly. And so he talks about that at great length. And of course, you have more contemporary scholars looking back at that, like Akil Reed Amar, who also has similar critiques also in retrospect. So you have this ultimate activist decision, which introduces this constitutional right, which is enforceable against the states, enforceable against democratic electorates, without the flimsiest basis in the constitutional text, et cetera. Some say that this, one of the many effects of Roe v. Wade was that it radically altered the presidential elections. Because all of a sudden, it dawned on people that the way to bring about constitutional change in America wasn't actually through the amendment process. That was the hard way. The easy way was just to win the presidency, and then all you had to do was appoint a bunch of your own judges, and all of a sudden, the elections to president became the most important instrument of constitutional change in America. And again, some people argue, I think quite compellingly, that Roe v. Wade was a watershed moment in the entire concept of how people understood presidential elections and the power of the president. Putting that aside, taking us to Dobbs for a moment, what Dobbs did was, in many ways, you have two different levels here, right? One is it was a restrained decision in reverting the power to make these choices back to the people, back to the electorate in different states. And in this sense, of course, the court defended itself on these grounds, saying, look, all we're doing is we're saying the people, the electorate in the several states have the prerogative to make this decision, to make this choice. But at the same time, of course, the court was also revitalizing the idea of the constitutional text and adhering to the constitutional text and basing their judicial decision-making on the substance of the constitutional text and nothing else. And I think one of the things we spoke about is that one way to demonstrate this is you can imagine a real mirror image of Roe v. Wade. You could imagine the activist reverse of Roe v. Wade. You can imagine a court dominated by conservative justices who recognize a right as part of the right to life, and right to life is an enumerated right in the Constitution, right? Unlike perhaps certain right to privacy under substantive due process, et cetera. Under the right to life, abortion is illegal in all states of America under the Constitution. That would be the activist conservative mirror image of Roe v. Wade, and of course that's something that we didn't see. I think that it's something which is extremely unlikely. I don't think anybody is really arguing that that's something that's likely that will happen under any constellation in the Supreme Court today.
Yeah. So this kind of leads to another issue, and you just hinted at it as well in your answer. Something I'm fascinated by is the fact that the Israeli court has really set the boundaries for itself, has set the guidelines and the rules for itself. You know, you could say that, well, every court must be doing this, right? The U.S. Supreme Court has certainly done this. Substantive due process, tiers of scrutiny, strict scrutiny, all of this stuff. None of this is in the text of the Constitution. The court has come up with this and thought, this is a good test, we'll go with this, and occasionally replaced it, occasionally upheld it, this kind of thing. That kind of limit seems to be focused on setting the limits on how the court does its daily work, how the court decides cases or interprets the text. You could say the same thing for other large courts like the European Court of Human Rights, which has come up with doctrines out of the blue, which at least theoretically are meant to restrain the court, leave power to the states, or in that instance, the countries of Europe. Whereas it seems like what Israel has done is to create the rules for itself, but they don't seem to be the same kind of rules. Here's how we will go about determining cases, interpreting statutes, in a way that it doesn't seem to feel especially beholden to the rules that it makes for itself. So all of that to ask you, what kind of reforms have been tried? Have any of these attempts at reform worked? Is reform a left-right issue in Israel?
Sure. Let me reflect for a moment on one of the things you said, and then I'll answer the question. It's interesting because one of the arguments that the court makes in Israel quite often is that Israel doesn't have a written constitution, and therefore the legislature and executive are far less constrained. There are far less limitations on their powers, and therefore the court has to step in and fill that vacuum by creating its own counter-majoritarian mechanisms, by creating its own limitations on executive power, etc. But the problem with that argument is that the court refuses to recognize that the lack of a written constitution also doesn't constrain the court, and that the court itself is missing critical checks and limits on its power because that Israel doesn't have a constitution. And what you have in many cases is, and of course, I think there are fair arguments to say that a determined court can do almost anything it wants. This is part of the institutional makeup of judiciaries all over the world today. But a determined court can do almost anything it wants with almost any piece of textual basis, right? One could argue that, and the European Court of Human Rights is a good example, right? Of the European Court the European Court of Human Rights has developed the idea of privacy, for example, right, to this all-encompassing right, which spans a huge scope of human activity, et cetera, based on, right, with no relation to what the original idea or word of privacy meant when the European Convention on Human Rights was passed, et cetera. However, there's a good case to be made that at the very least, judges in most jurisdictions, most constitutional types of adjudication, are still trying, even if it's lip service, they're trying to explain how their decisions are tethered to a text. And there's a phrase that I like from Martin Lachlan, which is judicial decision-making, which is subject to the discipline of a text. And even if you're cheating, even if you're saying things which are obviously baloney, at least you have to sort of pretend that there is a line which connects your judicial decision and the text. And what's happened in Israel, what you have in Israel, is that even that doesn't exist. So the court, on the one hand, gave itself the power of judicial review, invented a so-called Israeli constitution, but this Israeli constitution is formless. It has no limits. No one knows, on a textual basis, there's no one agreement, not even on the court, where the so-called Israeli constitution begins and ends, right? If I were to tell you, hey, send me a PDF with all of the Israeli constitution, no two PDFs would be the same. And just imagine how bizarre that is. And that's just as a starting point. So you have the court, which is unconstrained by the very idea of, I am bound by a particular set of words, and I have to justify what I'm doing somehow based on this set of words. And there's There's an Israeli politician that I like, who's also a friend, called Simcha Rothman, and he was very involved with the reforms. And he sort of quips that Israel has a living constitution. It is the flesh and blood judges is the Israeli living constitution, because the Israeli constitution, in every sense, does not exist outside the hearts and minds of the Israeli Supreme Court justices. That's where it exists in its sort of nebulous form and constantly changing. But to answer your question, the reforms, it's always a question whether to do this sort of post-mortem, right? This autopsy on the reforms of 2023, which are kind of dead in the water. But for those who don't know, the Israeli government in 2023 began enacting a series of measures which were explicitly aimed at limiting the court's power, at curbing some of the court's power. And this, side note, we didn't go into this, this is one of the most extraordinary harms caused by judicial activism. Because what happened in Israel is a complete collapse of faith in the constitutional project, in constitutionalism as an idea. And this is a spectacular backfiring of caused by the court, if you think about it, right? The court is trying to introduce this coerced constitution on the Israeli public, and what it gets in return is the entire public ceasing to believe in the idea of a constitution, and as a result, the electorate and its representatives pushing for more and more curbs on judicial power. And that's been the only real constitutional activity since then, has been to limit the court's power. So just to say, the Israeli legislature did enact a few limits to the court's power. They did it within the framework of that the court developed in its constitutional jurisprudence, and they said, okay, we'll play ball. If you're saying that certain types of laws or constitutions are part of the Israeli constitution, we will enact these constitutional amendments, and in this way, we will limit the court's power or roll back some of the court's reforms, etc. And what happened was, the court has struck down this constitutional amendment. The court has struck down what's called the unreasonableness law, which was enacted in 2023. And of course, I won't get into the intricacies here. I go into great detail in the book, but it's really remarkable. So the court sort of completely abandons even the idea, even the pretense of, okay, we have something which is kind of like a constitution. We're going to pretend that we're striking down laws based on this constitution. But on what basis are you striking down chunks of this constitution, which according to your entire jurisprudence, you just claimed that this is the Israeli constitution. Like there's no higher norm. Well, the court says, actually, there is a higher norm, which is the democratic essence of Israel. And that this constitutional amendment was so odious to Israel's democratic character, we just have to strike it down, period, without any even pretense of referring to a higher tier of law, to a higher level of law. It's worth mentioning, just for your own edification, that this ruling handed down in January of 2024, I should note at the height of Israel's war in Gaza, etc., was decided on a 8-7 majority, 8-7 member majority. So let's start with the fact that 7 members of the court did not think that this was a sufficient violation of Israel's core democratic character. And just think, how compelling is that argument to begin with if 7 members of the Israeli, which is far less partisan, I should note. The Israeli Supreme Court is considered far less partisan, sort of clearly divided between conservative and liberal judges, etc. More so, all 8 of the judges who did vote to strike down this law, this constitutional amendment, no two could agree on the theory, on the constitutional theory which enabled them to do this. There are no two same judges who agree with this. Is why it's a 700-page ruling. 700 pages. It's longer than this book.
It's longer than your book.
And this is why. So you have no two judges agreeing, and you can already consider how compelling these arguments are about the court's own power to strike down constitutional amendments. And finally, the last thing I'll say is, just because it's so entertaining, I have to. 2 of those judges in the 8-member majority had already retired by the time the decision was issued. So in terms of serving members on the court, there was already a majority going the other way. And this whole thing was engineered in many ways, and the decision was rushed by the Chief Justice so that it could include these 2 justices who could reliably vote against. So this is, I mean, it would be funny if it were not really tragic and genuinely dangerous to Israeli constitutional order, to Israeli social cohesion, etc. And again, you don't have to take my word for it. It's all detailed in the wonderful book called Rogue Justice.
I think for the sake of time, I'll combine, if I can, a few of our audience questions, which sort of follows up on what you were just talking about. I mean, it sounds like the Israeli court is essentially the lawmaking body. And obviously it hasn't been this activist, it hasn't been this supreme from the beginning. But I suppose the question is, what is the source of law in Israel if the court is behaving in this manner? And where is there any line, and where is it between legitimate judicial review, assuming you believe in such a thing, assuming you're not Jeremy Waldron, and you believe there is a place for judicial review? And as you know, in the United States, one of the first cases that I teach in constitutional law is Marbury versus Madison, all about the power/duty of judicial review. Where's the distinction or the line between legitimate judicial review and the kind of supremacy and activism that we've been talking about, with not just with the Israeli court, which seems to be making up its own rules and laws, but with other courts around the world in Western democracies?
Whose question was that? Do we know?
One and two.
Okay. So the short answer is, it's all in detail in the book. That's the lazy answer. But what I'll say is that it's actually very straightforward, both on a theoretical level and I think in Israel. It's extremely straightforward. And this is part of my point about the clubs sort of beforehand. I'm a constitutionalist. I'm in favor of judicial review. I think a lot of Israelis are in favor of judicial review for legislation. I think judicial review is a really important, not necessarily a critical in the sense that it's indispensable, but a really important part of a functioning democratic society. And it's a really good idea to have some kind of tribunal which can, decide upon whether the legislature has made some kind of decision which is contrary to the Constitution, to which it is also beholden, by which it has to abide. However, it's actually very straightforward. It is the people who is the sole origin of that power. It is only the people who can grant the power to strike down legislation, right? Who can limit its own power as an electorate, who can limit the power of its representatives, and say, we will establish this institution, which we will give the power, which we will give the license to perhaps impede or hinder the outcomes of the political process and the majoritarian process, et cetera. And Hamilton has this wonderful sentence, and I think in Federalist 21 maybe, where he says, after everything, we're talking about checks and balances and counter-majoritarian mechanisms and the Supreme Court, et cetera, but at the end of the day, all legitimate governing power has to stem from the people. This is a paraphrase. This is not the quote is in the conclusion of the book. But all legitimate governing power must flow from the people. And there's a wonderful example for this. This is a bit of a tangent, but of course in the U.S. Constitution, you have the Republican Government Clause. You have, and most people are not actually familiar with this. I've spoken to law students who've never heard about this, and I'm like, open your pocket Constitution. Republican Government Clause says every state in the Union has to have a Republican form of government. But what does that mean? So Akil Reed Amar, the Yale Sterling Law professor, explains that this means, and this meant at the founding, and it means today, popular sovereignty and majority rule. And those are the two foundational concepts of democracy, of a republic: popular sovereignty and majority rule. And that's the core element, and everything has to start from there. And what's so egregious about what the Israeli Supreme Court did is that it created essentially a constitutional democracy without a democratic constitution. It was this experiment in coercive constitutionalism where it said, you know what? The people aren't doing it. They're not getting their act together. So we're just going to impose it on them. We're just going to tell the people, you're going to have judicial review like it or not. We're just going to inform the people one day when they wake up that congratulations, a constitution has been bestowed upon you. You have received limitations on your majoritarian powers that you never knew about, that you never had a say in. And now you have to abide by this. And guess what? And this is the newest edition. You have no way to change it, right? No backsies. No backsies. There's no going back on it. So there's no recourse. You have no power. And this is actually the case today. According to the Supreme Court's official jurisprudence, the Israeli public have no channel by which to get their way, right? If the Supreme Court sufficiently disagrees with the public. And that's an extraordinary idea. I don't think there's virtually no country in the world which has such an arrangement.
Yeah.
I don't even know if I've remotely answered your questions.
That's a great answer. Sounds like the Israeli Constitution begins, you the people.
Right.
All right, well, I mean, I could ask you many more questions and listen to you talk for several more hours, but we're out of time. So everybody, please thank our guests.
Thank you.